you very much, Stuart. Good afternoon, everyone. I am delighted and honoured to have the opportunity to cross-examine one of England's finest advocates. Thankfully, the questions will only go in one direction. So I'm very excited to have you here, Nick. And I'll echo what Stuart said, you've had a really tough few weeks. We're delighted to have you here. Now, before I do start asking some questions, I'm just going to run through very quick, this is your life, just to give everyone a bit of context about you and your background. You were born in Nottingham in 1956, raised there, schooled there, and graduated in 1979. You became a prosecutor for Greater Manchester Police in 1981, and in 1983 you moved to the other side, joining Burton Copeland and becoming a partner within 6 months. Fast forward to 1998, age 42, you set up your own firm, Freeman. Now, as Stuart alluded to, you have an incredible list of former clients and current clients. Some of them include Sir Alex Ferguson, David Beckham, Frank Lampard, Ronnie O'Sullivan, Sir Ranulph Fiennes, Jimmy Carr, Jeremy Clarkson, that's been interesting, Andrew Flintoff, Colin Montgomery, Wayne Rooney, Dwight Hall, Paddy Guinness, and local celebrities including Sean Ryder, Ian Brown. The question I have for you when I read through that list of world-renowned names is why are men so bad at driving?
Good question. The unreasonable doubt is probably testosterone.
I won't ask you to elaborate on that.
I don't think it needs any elaboration.
I want to go back to your time, to your early life. I'm really trying to understand what got you into law, how you developed an interest in law, because I understand that you were relatively young when you decided you wanted to be a lawyer.
I was walking back from Sunday school with my dad. I was 7, and I was holding his hand, and he said to me, "What are you going to do when you leave school?" I was really shocked at the question at that stage. So I said, "What owns the most, Dad?" And I have to say, I've never gone into the law for the money, but that was the question, that was my reply. And he said, "Well, lawyers earn £4,000 a year." That was a year, not an hour. This was back in 1963. So I said, "Fine, I'll be a lawyer." And then I said, what do lawyers do? He said, "They argue for a living." So I thought, wow, arguing for a living, not getting a clip down the ear, and earning a reasonable wage. And that's how it started. And at the same time, I'd just gone to a new school, and we had fortnightly tables tests. And first fortnight, I wasn't interested, got 20. Second fortnight, wasn't interested, not after 20. And my dad had a chat with me. He said, "If you think that I'm paying this money for you to whatever, and you've got another thing coming," he said, "next fortnight, everyone you get wrong, you're going to get one stroke of either." I can't remember whether it was the hairbrush or the writing. It sounds quite barbaric. It was true. This is obviously going back to a time when beating was accepted, not to me. But in any case, to cut a long story short, the next fortnight I got 13 out of 20. I didn't get touched. Next fortnight, 20 out of 20. And literally, within those 4 weeks, from being bottom and not living it down, and then sort of being at the top, thinking, wow, this is fantastic. That's always where I wanted to be. And that's really that lesson that I'm talking is guiding.
And so that was obviously a relatively young age. Was there anything specific you did during the remainder of your education in order to sort of progress that?
Well, I actually was quite shy, I never got involved in debate or anything like that. Did all my law exams. And I'll be honest with you, I really hated the law. I couldn't stand up doing my articles, and I hated it. But I've done all my part twos. And I got a job as commercial lawyer in 2 firms, and I've also got a job in Hong Kong. I was thinking of joining Hong Kong, please. I just wanted something exciting. One of the solicitors in my practice, in the practice I was doing my articles, without my permission and consent or knowledge, entered me for an advocacy competition for the local law students, etc. And there was a £50 first prize, which was a lot of money because I was supporting myself. We had a grant of £50 in those days. I entered it, got through the preliminary rounds, and just loved it, and actually got to the final and won it. And instead of taking the job that I was going to take, I completely redirected myself. And instead of thinking how frightened I was of advocacy, which is probably a natural thing for just locally excited me. And my first job was before positions, Great Manchester Police, before the CPS, 1981, 200 applicants. And I have to say, I had two fantastic referees. One was a local judge, passed away now, Ivor Taylor QC. And he actually sent a letter saying that if I didn't get the job, he wanted a full explanation why. So I think it was probably the excellent referees as opposed to anything to do with me. But that's what started me, literally. First day I was watching, second day, court one, Manchester City magistrates prosecuting the drunks and the prostitutes. And I can remember it vividly because there was the chair of the bench was a guy called Raffles, Major Raffles. And he knew one of my referees, and he knew I hadn't done anything. And he said to me, he said to a defendant, "What are you drinking? What are you drinking?" The guy was drunk. I said, "What are you drinking?" He said, "I think it was Bollick." He said, "Bollick?" He said, "That's nasty." And then he turned to me a few minutes later and said, "What are you doing on Friday night?" He said, "Come round for supper." And so that was literally my first day on my thinking court.
And just tell us a little bit about the time as a prosecutor. We'll come on to you turn to the defence, but what did you learn? How valuable was it in your later career?
Incredibly valuable. Incredibly valuable. There was a guy in the army, ex-police officer, who didn't. I think he thought I needed to bring him down a step or two, and was probably right. So when I finished in the morning, and you were travelling all around Greater Manchester, so it's completely peripatetic, different court every day, so you were thinking on your feet. But typically what would happen is you go back to Manchester, having finished your list, and he'd say, "Nick, here you go, off to Bolton, do the road traffic." And nobody liked road traffic, it was horrendous. You get 50 files, you've got no chance of reading them. And I used to do that regularly, and it was a very interesting process, and he had no idea what a favour he was doing to me. But I do remember a specific case. I was prosecuting a drink drive case in Oldham Magistrates Court, and the solicitor defending was a chap called John Goodman. And it was a straightforward case. I couldn't see how I was going to lose it. I produced all my evidence, sat down, waited for John Goodman to try and salvage an impossible situation. Then I heard these words, "I've got a submission and no case to make." And I remember sort of sitting there and thinking, and then he sort of said, "There's no admissible evidence as to what the reading was because I had omitted to hand in the certificate from the machine. You have to prove that the machine's working and that it's properly calibrated." A stupid, stupid error. But I remember to this day, just a cold sweat, feeling utterly sick with myself. Apart from sort of personal flagellation, I vowed never to let that happen again. And I thought, the knowledge is the key. You have to know this subject inside out. And I've been prosecuting actually for 3 months, and I was approached by a very good local lawyer called Ian Byrne, who was renowned as being the best criminal lawyer in Manchester. He was a fantastic advocate, fantastic lawyer. And he asked me to join him. He said, "I've been looking for someone like you." But I'd agreed to stay 2 years prosecuting. So I stayed for 2 years. And at the end of that time, I then joined him. But in my last weekend, I went to the police library and I wrote out in longhand every single drink driving case I could find, because I realised at that stage the value in knowing the law. And in those days, in the sort of early 80s, 1980 to 1983, if you knew the law about drink driving, and a conviction was impossible because the police had impossible hoops to jump through. So, I didn't realise where it was going to lead, but that's what I did. And what happened was, once I started defending, I was defending heavy crime, got on well with bank robbers. Most of them were decent people who did bad things as opposed to evil people. But what happened was, the bank robbers were particularly getaway drivers, that were known for drink driving, which obviously had catastrophic consequences for them. And they'd asked me to defend them. And it wasn't legal aid, it was £500 in those days, which was not a bad sum. And I just won every case. And then eventually what happened, and then I started getting minor celebs like local drag artists, Fufu Lamar, Sean Ryder, who still hasn't paid me. And Frank Worthington, the Leicester footballer. And what eventually happened was that the private work sort of just pushed me out from the legal aid work. But there was one interesting legal aid work that we made all the men constrained those riots. And I was lucky enough to be instructed by one of them. There were 4 defendants charged with murder. And it wasn't a very serious case. This guy was called Andrew Nelson. Anyway, so I went to see him first time, and I arrived in Strangeways. I was always very fascinated with Strangeways. Just for me, it was a really exciting place, seeing real criminals, seeing cells. It just stimulated. And I walked into the room where he was, and he said, "Wayne trainers." I said, "I'm sorry, I don't understand what he's saying." He said, "Wayne trainers, all the briefs." I said, "Listen," I said, "put your cigarette down. I'm here to defend you. It's legal aid. I'm going to do my very best for you. I'm not buying anything." He says, "If you don't buy the trainers, I'll attack you." Stood up, shook his hand, and walked back to my apartments. And I turned my back on the case. Legal aid was a £200,000 case, which was an awful lot of money. This was mid-late 80s. But I just took the view then, I'm not paying for clients. That's just from one angle you go across. And funny enough, he did come to me when he lost his case. He wanted to conduct the appeal. And I was very happy to tell him where to go. And first, he actually did a television program about his involvement in the case. He never mentioned that story.
So you mentioned in your book, you talk about motoring laws being intricate, littered with anomalies, technical points, and therefore potential loopholes. And you also mentioned that last week before you joined Freeman, how you wrote down every single case.
Yeah.
Can you just talk a little bit about your insatiable desire to understand and know everything about this?
Well, I like many of us, we like to win. And our armory is knowledge, it's fact. So the more knowledge you have, the more advantage you've got. It's your nuclear weapons, it's the one that you learn the other side of the way. And it's basically down to it. For me, I've always said it's like playing chess, but it's also like preparing for the exam. And that's what it is. Because most of my cases are trials. Literally every case I do is a trial. And the better you are, the best I'm winning. And, I'll be very honest. I love to win, and my clients are the fortunate beneficiaries of my desire to win. It's self-motivated, but obviously the client's very fortunate to have someone who's so keen to win. The more knowledge, the more you read, the more you apply your brain outside the box. There are so many cases that you look at, and you just try. And sometimes, you can't find an example. I can tell you a story of I had a guy who was an architect, and he came to see me to look at his case. He had 4 previous convictions for driving, and I looked at his case and I said, "I'm really sorry, I just can't help you." I said, "All I can do is try and keep you out, suspend the sentence, let you go for." And he was quite abusive to me, talking about supposed to be his hot shot lawyer, etc., etc. So I said to him, "Look, you tell me all your offences, because I haven't got a clue." In any case, he said, "I want to pay you to go to court and find something." So I was concerned about this, because obviously you go to court, you want to have issues in your mind that you don't going to argue, and often you win with mainly you win with other arguments, but to go to court with nothing is something I've never done before. And actually I phoned the SRA, as they were in those days, the law society, I can't remember, and I asked, "Is this permissible? Because I haven't got any defence, I'm taking a certain amount of money off this guy." And they said, "Absolutely, if he wants to pay you to do that." So anyways, the trial starts, the officers give their evidence perfectly. I can't see anywhere to get it. I'm now going fishing. And I said to the officer, I said, when this guy blew into the mouthpiece, what did the VDU show? So he said, "Void. Bing, bing, bing." I said, "I don't wish to be rude, officer. How do you spell that?" So everyone looked at me like I take my senses. And he spelled it correctly. I said, "Thank you very much. I have no further questions," and sat down. And I'd actually read in a law book, it was a very good point, that actually void means the machine's not working. Voided, ED on the end, means that you haven't provided sufficient quantities of breath. So I made it was a closing speech. The court had never heard this talk before. The case was adjourned for an expert to consider. They came back 2 weeks later, and the big go had to be right. And that was the end of the case. It got across as well, and he was very grateful for that.
And what's interesting there is, you cross-examining somebody and they say something. I think, again, you say in your book, I specifically never asked them to repeat that in case he said void it. with just that little nuance. It's what
Two letters, save his neck.
And it's not the only time we've worked police officers over on the stand. Again, I read that you won a case by asking the police officer if he was chewing gum.
There was a drink driving case for a well-known person's nephew. It was in Stockport. And I knew the prosecutor, he was a very experienced prosecutor. The case was very well. I just, you look at the defendant, you look at everyone in court, you study body language. And this officer appears to be chewing. And I thought, well, I'm just going to rip the rest of it down. Because you shouldn't chew. You've given evidence on it. You should have respect for the court. So I thought the best I was going to get was an apology. I'm sorry. Again. So my first question when I stood up was, officer, are you chewing? No. Wow. Well, what's in your mouth? Well, it's medicinal. Oh, wow. So when you said you weren't chewing, you were? Well, yes. Well, it's medicinal. Tell us what it is. Well, it's airway. Now, the facts of this case were very simple. The guy was in his car. He said he was asleep. The police officer said it was 3 o'clock in the morning. He reversed the car a short distance and banged in the car and arrested the drink driver. So I was able to say to the court, look, this guy's taking the oath. He's standing 15 feet away from me. And with respect to him, he couldn't lie straight in bed. And you're being asked to believe beyond reasonable doubt disputed evidence with the defendant would be drunk. Really? That was the end of the case. That was it. How could you believe it? You couldn't. That's just watching. I didn't know I was going to get that response. I was in the northeast doing another drink driving case for a very heavy, quite a bad guy. And there was a point in the case where I actually said to the court, well, could the officer please go out because I want to make a legal submission and I know what the officer did want me to say because it may affect his future evidence. So I said, please warn the officer about speaking to him. I'm sure he will. So what the officer didn't know was that I had a police surgeon outside who I was about to get to evidence. So I'm making my legal submission. And after about 10 minutes, the police surgeon comes over to me and says to me, he says, that officer is sitting next to the next guy and he's telling him everything you said. Thank you. So I paused my legal submission and said, I've got another submission to make. Let's get the officer back in. And I made a submission we could no longer now have a fair trial because the evidence has been contaminated. He tried to argue that he hadn't quite said, but obviously they preferred the evidence that the police surgeon that case went. And actually, as I went out of the court, he was waiting for me. And he approached me, and I honestly put his face in my face. And I took the initiative and said, look, we just need to be truthful. It's not really issue. Take responsibility. Well, unfortunately, that was the end of it.
And so, what we're learning here is a little bit more about the combination of knowledge and also having wits about you, being an advocate, thinking on your feet. Bearing all that in mind, were you offended when you were labelled Mr Loophole all those years ago?
Well, I have to say I didn't like it. You get George Carl, the great defender, you get Nick Freeman, Mr Loophole. I mean, it's a bit underhand and nasty. And it's sinister. To be honest, it's everything I don't feel I am. So I didn't like it, but there were various press members who were fascinated with what I was doing. Word gets out very quickly, particularly if you engage with the press. And I always have to. I've always been very honest with them, very straightforward. And they want to know the legal points. You tell them the legal points. You answer their questions. In any case, so what happened was one particular gentleman called Paul Gloucester from the Express, and he actually coined things. And there were headlines on a weekly basis. Mr Loophole was this way. So I didn't like it at all. But what happened was there was a solicitor in Ashton who I knew, sadly he's passed away. But he won his first speeding case. And the headline in the I think it's the Ashton Gazette was the local Mr Loophole. And the penny dropped. And that day I spoke to a paper and made inquiries about trademark. I had no idea then that it was going to be so valuable no idea. But what I wanted to do, I did realise I actually wanted it for me. I wanted to protect my reputation, because what I did was on social media, on Google, and I looked under the heading of Mr Loophole, and the advice that was given was completely nonsense. So I needed to protect my own professional credibility and reputation, and so I just decided to trademark it. It cost a couple of grand, and it took a while, but legally it was one of the best things I ever did.
And you don't have to answer this, but have you ever enforced that trademark?
I have several times. People have had to pay out. So yes, yeah. When people buy it, there was one guy who was very persistent in using it, but it cost him a significant amount of money. But not regularly. I think I've 4 times. That's all. But yeah, it's mine. I've worked hard for it. I've earned it. And the beauty of it is, you can have a private life and you can have a professional life. And very few, in the present, Mr. Freeman is private, Mr. Loophole is public. I'm very happy to talk about law, and that's what I do. I think that works for me.
And what I want to talk today, generally at the conference, is talking about building a brand, protecting it, developing it. Can you just tell us a little bit about how you've used Mr. Loophole, or how it's helped you, rather than just being known as Nick Freeman?
Well, I got Mr. Loophole, it was me. The type of work I do, as I say, it's trial work. So you have your client sitting behind you, he's paying for it, and he's going to either say, and this was really before social media was really kicking in, he's going to form a view about whether it's had value for money. So he's your best advocate if you're doing your job properly. If you're not, you're going to be destroyed. So he's going to say, amazing, rubbish, van ordinaire. So as long as he's going to say amazing, she's going to say amazing, that is all you want. And off it goes. And then, for me, I've always engaged with the press. You cannot sneak into court with certain clients that I'm fortunate enough to defend. But the press has followed other very interesting cases, and the press have been very helpful in helping me to establish a brand. But when you're establishing a brand, it's your reputation. You're selling something. You're selling yourself. You're selling the skill set. You're selling what you do. So you're always under pressure to deliver, to do your best. And that basically comes, as we all know, from real hard graft. My first, what I call, I defended a guy from Coronation Street. That was probably my first, what I call, big drink driving case. And I finished my day's work. I then started prepping it. Got up at 4:35 in the morning to get off to a court in Wales, and I got beaten. And I realised you cannot do justice behaving like that. You need to go the night before. You need to find the time to prepare so you know it. Like an exam, you can't pick and choose. You've got to see this through like a game of chess. Every single move, know every single piece of law, and even bouncing off other people. And I've always had 1 or 2 panels that I bounce my ideas off. And you're thinking, how am I going to win this case? What are the points? What are my tactics? So you've got to be passionate about it. And, if you're doing your job and you don't, it's a job, turning up, you're not really that bothered. It's never going to work. But I think doing criminal law, you're dealing with such interesting people. It's hard not to get really involved and care about it, because you're going to get an immediate reaction from the person who defended. So that's probably the best advice I can give. I suspect everyone here already cares and works hard, and it's difficult. I have been very fortunate. Would Mr Loophole survive now? Probably not, because what's happened is as a consequence of courts, they think they've been ambushed, and they haven't. The prosecutors, for whatever reason, haven't done their job properly. They've fallen short in various regards. I'll give you an illustration. I went to Middleborough Magistrates Court a long time ago, and I always go into court and look at the courts, just get a feel, engage with people, establish eye contact. And the case on before was a drink driving case, local solicitor on legal aid, and his client had been out of work for 2 years, and he wasn't there because he'd just got a job on a boat. And his lawyer made the most appalling, half-hearted effort for an German. Not surprising he didn't get it. And I remember thinking, how sad is that? This client doesn't say it. In any case, he went off, so I stayed in court, so I'm curious, I wanted to listen what happened. And of course, the Crown rattled through their evidence, closed their case, and the magistrate had just about every trial. I sort of tentatively stood up, looking slightly embarrassed, pretended I was some sort of quasi-Mackenzie friend. And I said, look, I'm sure your legal advisor will tell you, but actually the Crown case is fatally flawed because the prosecution haven't used any evidence of the statutory rule in Section 77 of the 1988 Act. I know your legal advisor is aware of that, but I just thought it would be important to say it and call it. I just came back in the court. Well, you know, that's what happened. But the lawyer who dealt with that, he just didn't care. Another case that I had, a local case in Macclesfield, and a local sister came up to me, and he said, what are the bench like? I said, fine. He said, well, what am I likely to get? I said, well, how fast are you going? He said, well, I'm doing 105 miles an hour. So I said, well, what machine is it? He said, no, we're pleading guilty. You don't know what machine it is. I've tested it. I said, look, I'm just about it. It sounds like arrogant. I said, I'm just about to do this with you. So for me, I said, and I did ask him, I said, are you going to be paid private? He said, yes. And for me, that's just not how you do the job. It is if you don't care, you're not bothered. But actually, I think we all have a duty to ourselves and to our clients to do the best we can so that they get it right. In any case, I was lucky enough to win my speeding trial. His client then came over to me and said, can I have it? Obviously, I said, thank you, but your sister may want to look at the advice again.
Okay, we're going to move on to talk about some celebrity cases. I also want you all to play a part in this. These are quite famous cases, but some of them from a while ago. So I'm going to take up the cases, I'm going to give you 3 potential defences, and I want you to decide which one you think was the defence that Nick put forward on behalf of his client. So the first one is Sir Alex Ferguson. He was charged in 1999 with driving on a hard shoulder of a motorway. Again, a very famous case. A lot of you might know this, especially as we're here in Manchester. Did Nick put forward the argument that Sir Alex has had a family row and therefore needed to rush home? Secondly, that he thought he was on a smart motorway, so he was perfectly fine. Or thirdly, I apologise for saying this, that he had diarrhoea. So, who thinks number 1 that he had a family row? Anyone? Number 2, he thought it was a smart motorway. Okay,
I think
number 3.
There
There we go. Well, Nick, just explain how that provides a workable defence.
Well, the interesting thing is, you look at, he wasn't charged with speeding. He was actually trying to drive on the hard shoulder. So it actually, if you have a medical emergency, it provides a complete defence. So obviously, I looked at it all, having taken his instructions. And the interesting thing was, from a legal perspective, had he had the problem before he set off, he would not be able to avail himself of that defence. He did have the problem earlier on. He'd been to see a doctor, pain some stuff, supposed to have sorted it out. And by the time he finished his day, he felt well, things had settled down. And unfortunately for him, on the way back, he had these terrible stomach cramps. And was faced with 2 alternatives, and one was particularly unpalatable. So he was pulled over by the police, driving on a hard shoulder. He was trying to rush to the loo at Old Trafford. That was a purpose. So, the legal point in that was, of course, if you've got it, you can't argue. And I had a letter from his doctor, I think Dr. Stones, who confirmed that he had it, and effectively was cured, the stuff that was sorted it out. So he was all right to drive home.
And crucially, then, the nuance is that at the time he set off to drive, he thought he was recovered. Had he not, there would have been
No argument. He would have been able to argue special reason.
Okay, let's move on to another one. Jimmy Carr, 2009. He was charged with the offence of using a mobile phone whilst driving. Did Nick say to the court that Jimmy was dictating a joke on a voice note? Did he say that Jimmy had been framed by the police? Or did he say that he was receiving urgent medical news and had to answer the phone. So he thinks number one, he was dictating a voice note. Okay, about powerful ruler. Number two, framed by news. Just one. And number three, he was receiving urgent medical news and therefore had to answer the phone. Okay, well the answer here is number one. I know the law has changed and we'll come on to that. But just explain why dictating a voice note at that time was not unfair.
Well, this was new legislation going back to 2009, I think it was. So phones didn't have so many functions in those days. So it was basically the spirit of the legislation was designed to stop you making calls, receiving calls. In other words, an interactive communication. What Jimmy Carr was doing was he's actually recording a joke, so he was using the phone as a dictation machine, dictating machine. So there was no interactive communication. And it became known as Carr's law, so I thought, I got the prosecution to agree that's what he was doing. I wanted to agree that I'd been prosecuting when they were prepared to make a formal admission that he was recording a joke, so that dealt with that, dispensed with that. So what we had to do was the law. The law was actually quite clear. It's got to be an interactive communication. The prosecution said they're going to take me to the High Court, and eventually they started proceedings and then back down. They accepted what they said was right. And what's astonishing is, until the beginning of this year, because I defended another footballer earlier this year who was driving coffee in one hand, phone in the other, and the case was ultimately discontinued because they couldn't prove he was using the phone even though his mouth was moving, looked like he was using it, and they couldn't see anybody else in the car because of the dark windows. The point I'm making, when you're using a mobile phone, it's actually the biggest distraction, whether it's handheld or hand-free, during driving, it's 4 times more likely to have an accident. And yet the government have only just this year got around to changing the laws so basically just don't touch your phone when you're using it, whether it's interactive or not. And I find that pathetic that they take so long. When you think that it's as dangerous as drink driving, it's a huge distraction, and they spend every government professes to be so concerned with road safety, and then we got around to it. I think it was April this year.
And so the law has changed, but at the moment we have so many distractions in the car. We have, even if your phone's in the cradle, you can use maps, satellite navigation, music, kids in the back. Are all of these potentially?
They're potential nightmares because we're told, aren't we, you can't use your phone in your hand, but so long as it's hands-free, you're fine. Or eating a sandwich, doing a sat nav, having a drink, talking to your passenger, dancing to the music. All these things are fine until it goes wrong. And the moment it goes wrong, God forbid, you're involved in an accident, all your activities are seriously aggravating. So if you're involved in an accident causing serious injury, you will be charged with an offence. And your offences are coming out. Due care causing serious injury, dangerous driving causing serious injury, that's been out for about a year now. So the motorists do not understand the significance of doing things which on the face of it are legal until you have an incident, and then of course they seriously aggravate the situation.
Okay, let's come on to the third case. 1999, David Beckham was caught speeding at 76 miles per hour in the 50 zone. There was no dispute about the speed. But which defence did Nick put forward? Did he say David was being chased by the paparazzi? Did he say David was late for a game? Or did he say David's flip-flop got jammed onto the accelerator? So who thinks number one, chased by the paparazzi? Famous one. Nick, what happened?
Well, I was very lucky to get a call to defend him, and I went to see him in Carrington, the training ground. And the first thing he said to me was, I was chased by the paparazzi. Wow, straight away I realised the significance. And so I looked at the law, and the law says duress of circumstances very rarely used. But if someone's driving in such a way that you think there's going to be an accident which could cause death or serious injury, the law enables you to boot it. And in this particular case, he was being chased by the paps, and he made 399 calls within 90 seconds of going through the camera. I did say to the judge at the Crown Court, I would this guy has amazing legal knowledge or actually what happened is genuine. I argued it as a defence. I argued it in the magistrate's court. I mean, I've never seen such a bona fide trying to get into court. You cannot imagine the sort of hysteria surrounding him. In any case, I conducted the case of the magistrates, and clearly the magistrates just revelled in the occasion. It was, you're losing, you've lost, no special reasons, and instead of a 6-month ban, which would be usual, you get a ban for 8 months, no, you can't have your license back. So it was, I thought one thing's for sure, I'm going to get that 8 months out to 6 months. And actually what happened was, I got his license back that afternoon, went to a judge, got his license back that afternoon. The case was listed for a week's time, and I remember phoning the agent who watched the magistrate's court. It was the first time I met him. I said, I hadn't seen the license. I said, right, I've got a council conference with council and such and such every day for free. I said, what do you mean? He said, you're doing it. I said, we get council. Well, I know my place. Crown Court, we get council. In any case, he said, you do it. So this was an opportunity. The Crown Court case before, would have run away. I thought, let's do it. So it was fortunate only a week. So I have to say I didn't live and breathe that case. I knew every curve spin on the A54. I knew this case inside out, backwards, etc., etc. And I did argue the case in the same way that I argued it in the judgment of John Woodward, who was a car enthusiast, which I thought was quite significant because David was in this Ferrari. Just these things help. And he said to me, I accept every word that David Beckham has said. I accept that he was being chased. I accept that this perhaps was driving dangerously close to him. And I accept that the likelihood was that there was going to be an accident. But I don't accept that death or serious injury would necessarily follow. So in other words, I'd lost that case on trial. So I then stood up without special reasons. I went through them, 4 special reasons, 4 things, 4 ingredients. I retired for a very short time and said, yeah, special reasons, no endorsement, no return the 8-month ban. And that was that.
Okay, and as lawyers, we often, when we get a new case, we want to meet our clients with all the documents or the papers, we don't want to meet with them. There's a tendency for us to want to take instructions and get the full story about whatever issue they've got. My background's in commercial litigation. I want to understand from them how the dispute's arisen, what the relationship is between the parties. But the work that you do, often you either don't meet the client or you don't let them talk. And in your book, you said a very interesting phrase, which is don't talk unless you can improve the silence for your defence. Can you just talk about that little?
Look, experience has shown that cases tend to go downhill once you get to half time. The moment you put your client in the box. With respect, for a whole variety of reasons, you tend to have a problem because you've lost control. You've got no control. You're in control up to that point. Obviously, with someone like David Beckham, if it's a defence that you're running and you need to give evidence, obviously you've got to call them. But I sort of stumbled when I was thinking about how to defend people for speaking. And there's a section 122 of the Magistrates' Court Act, and it's a bizarre section because it actually says the client is not deemed to be absent if his advocate is there, if his lawyer is there. So that got me thinking, how are they ever going to be able to identify the client? And I spent a lot of time over several years not even needing to speak to my client, not meeting them. They paid the fee, and I went around, and the first one was actually awarded from a district judge in Manchester, and he was driving his Aston Martin in Manchester. And I said to the officer, I said, I think he was playing for Burnley at the time, and I said, did you know who the man who said he was actually awarded? Did you know whether he was actually awarded? Or could it have been someone who was familiar with those details? And he said, I don't know. He says, of course it could. End of the case. What the police needed to do is they needed some sort of photographic evidence to confirm that. And it was sloppy. It was their fault. They could have rectified it. And now they do. And what happened was, over the years, they gradually got better. And I remember going to London to Bow Street shows, and I was defending a very, very, very a world famous doing business, I'm not going to name him. And I had his license. And we spoke to the officer. First of all, I went to the court and I realised I was in the district judge's court. I managed to get the case through. And I was cross-examining the officer and I said, this guy who said he was such and such, you didn't know him, no. So, well, how did you establish identity? He said, I looked at his driving license. I said, no. What did his driving license show? He said, well, it had a photograph on it. And I looked at the photograph and I looked at him and I could see it was one and the same. I said, that's interesting. I said, I'm going to hand you a document now, officer. I'd like to have a look at it. Tell us what it is. So the adjutant pulled out the old license from my pocket, got the adjutant, you can take it over, please, thank you. Took it over. The officer started. Now, what is a document for an officer? It's a driving license. I said, it's a photograph on it. He said, yeah. I said, would you like to reconsider what you just said? He said, yeah, I got it wrong. End of the case.
So it's one of the old style paper licenses.
One of the old style paper licenses, yeah. Of which I still have.
For that one.
I'm not sure I'm getting away with it.
And you
So
talk
fun
about
enough on that point. I was very lucky, traveling along to programs now. And shortly after, literally a week after the first one, I was driving back from London in a nice car. This sounds just fun. But an officer pulled me over. He'd been following me. I wasn't speeding, I wasn't doing anything wrong. He pulled me over. And he said to me, can I have your name, please? I said, you're joking, aren't you? It sounds really heavy. He was like,
and I know this is really important, even when dealing with celebrities. And I know you just talked about Ashley Ward, but there's an even more remarkable one for you with Colin Montgomery related to identity.
Yeah. So I went down, you can probably help me with where the court was, but it was down south. And I went into court, and there was a lady barrister prosecuting. And I remember seeing this lady barrister a year earlier. And a year earlier, we had a case, and she completely forgot to produce any evidence as to who the driver was. So she bought all the speed equipment, everything perfect, but left something fundamental out. So I did say to Colin, did the police recognise you? He said, well, I think they did, but I'm not sure. So I said to him, she was saying this to us, we ain't arguing an idea here, but we've got other arguments. So I go to speak to her, she said, well, what problem one of the officers isn't here? I said, well, was he the officer who conducted the speed check? I said, well, fine, I'm happy to get ahead of that. It's never been lost to you. So she agreed to that, I would. And the officer gave evidence, and he simply said, I stopped Mr Loophole. So I waited at half time for the magistrate to go for their coffee. I went to speak to the legal advisor because I was thinking it could include them. And I said, am I missing something? Or have we heard sufficient identification? I said, thank you. Terms of speech. And that was the end of that case. You just don't know. I mean, how she forgot to do it again, I just really don't know.
And you've mentioned many times closing speech. This is quite unusual in your time. Can you just explain why you like to be closed?
If you make a half-time submission, the crowd went absolutely right to reply. It was and still is hard to rectify a legal deficiency at the end of the case. It is hard. I have to say, I think you saw I was defending Soapstar. In this case, we called it like that. It was down south. I'm obviously not going to name this lady. It wasn't the press. And it was a drink drive case. It was quite a complicated drink drive case involving lots of expert evidence, etc., etc. And the prosecutor was really, really helpful to me about certain things that I needed anyway. And I noticed when the police officer gave his evidence, and I had an expert in court, he left out a glaring omission, which related to something which was fatal in this case. Fatal, no discretion, end of this case. So I was taking them in a different direction. And we then got beyond half time, and then my conscience, it was affecting me. I thought, well, this guy's been so good to me. it's now too late for him to do anything about it. And well into my case, I've already called my client. I'm going to tell him. So we thanked me. Stood up, made an application to call further evidence. The judge granted it. I'll never do that again. You have to be ruthless. You cannot let. And that's why when I have friends who I defend, I always say to them, well, I'm defending you, you're not my friend, you're a client. You just have to be. That was the only occasion in my career that I've let emotional sentimentality get in the way. It cost me the case.
Nick, we've got a few minutes left. We're really keen people in the audience get to ask you a few questions. I've got one or two of my own that I just want to ask you quickly. But if in the audience you do want to ask questions, put your hand up and we'll come to you as quick as possible. One that I've heard, I don't know whether this is right, but is sneezing a defence or having a sneezing thing?
In a car, because when you're driving, it is. Absolutely, because you're losing control. And if you have a sneeze, I mean, look, if you suffer from hay fever or if you've got a cold and you drive a car, then you need to be aware. But if suddenly as you're driving, you get a sneeze and you have an accident, absolutely. Obviously, you're trying to pull over what you need to do. That's happening. You need to pull over and stop if you can. But potentially,
okay, is it still legal, or can you be prosecuted for driving up to 10% over the legal?
it's interesting because the net, it's a story I think that I commented about a few days ago. Apparently, the net police say that they've reduced the level of the tolerance from 10% plus 2 to 10% plus 1. Some region GP who's picked this up and they interviewed me about it. And the tolerance then for years has been 10% plus 1. So in other words, if you are driving, the speed limit says 70, that is the speed limit. But the ACPO guidelines allow 10% plus 1. So in other words, you will not be prosecuted under 79 miles an hour. If you're traveling at 79 or if you're traveling at 34, is it 34, 10%? It is. Just 10% plus 1 you're okay, 10% plus 2 you can be prosecuted. And it did used to be 10% plus 2.
Okay, one final question for me before we go out. If we are stopped by the police and asked to provide identity at the roadside, whether we have it on us or not, should we provide it? Should we?
Yeah, you should provide it because the police now have the power and the page to arrest you for not playing. So definitely provide it.
Okay, right, let's open it up. Does anyone have any questions for me? This is your opportunity, probably the only one you're ever going to have to get some yes, we'll just bring the microphone over. If you just tell us who you are and ask me a question, that'd be great.
Hi, I'm Tracy from Looking Direct. You did mention removing all emotional sentimentality from the job. Is that one of the reasons that you think you've been so successful? Because you did mention at the outset that you're representing good people that have done bad things, but that's still potentially a little bit contentious in that you know ultimately they may re-offend or do something quite bad in the first instance.
I'll give you a story which probably illustrates the point. I represented a guy who already got a conviction for drink driving. He was charged again with drink driving. And he was twice addicted. He hit a car. Family was on the way to or from Legoland. The family all sustained life-changing injuries. And he was charged with, he ran off, he was caught, walked back, and astonishingly, the police only charged him with drink driving. And the evidence was that when he was blowing the machine, he was messing about. So they thought, right, we'll take some blood. Took blood, we consented to the blood, and it was twice as blood. So I looked at this and immediately thought, they couldn't take blood. It's an unlawful taking, because if someone's messing around, you charge them with failing to provide. And if they're me prosecuting, I'd charge them with driving whilst unfit, and also charge them with dangerous driving. Pleaded not guilty, we're only charged with drink driving. I waited till the end of the 6 months, and then I phoned the prosecution and pointed out that actually the blood sample was unlawful and they had their case. They agreed they discontinued it. And I was then asked by the meeting, when I meet the family on television and explain what I've done. And I did. And I tried to explain to them that the defence lawyers do a job. We're not doing anything wrong, but we're acting within the law of the land. And what is the alternative? For me to say to the prosecutor, excuse me, we need to have a look at this. You got it wrong. Oh, thanks very much. That wouldn't really fit comfortably with who we are and what we do. Do I feel good about it? As a lawyer, yes. Obviously, so I met the family, it was a horrendous meeting. But my point was, why isn't anyone interviewing the police officers who conducted the procedure, they're trained? Why isn't anyone interviewing the various prosecutors who looked at this case? And for me, it's lack of care, it's lack of knowledge, it's lack of care. And they are the people responsible for these acquittals, not me. So I hope that answers the question for me. If I've been emotional about it, absolutely I've got no chance. And I'm then doing a disservice to my client.
Anyone else like to ask me a question? Right at the back. Sorry.
Victoria from the Integral Legal Costs. You said that the law is catching up with you and changing and amending the law to ensure there are less loopholes. Is that therefore making it more difficult for you to find loopholes?
Well, yes, but what I meant to go on to say was that we've got the CPIA and defence laws now. In the early days, I could stay off record, so when I defended Beckham, I actually stayed off record. The prosecution phoned me saying I'm acting. I said, you'll find out if I'm not prepared to tell you anything. You could do that. I used to turn up at cases for high-profile people and be off record. And then, obviously, if you like, it's an ambush. The prosecution get a shock because if I'm involved, they tend to prepare the case in a slightly different way. Now you have to disclose the issues. Obviously, you have to disclose who's defending. So it's much more akin to the civil procedure. And for me, that doesn't fit comfortably with an adversarial system. It's an adversarial system. And if you're having a fight with someone, you wouldn't tell them, I'm going to wait outside, I'm going to do this, I'm going to do that. So we now have this silly situation where we're supposed to discuss the issues, so you're sort of a bit hazy and fuzzy about what you discuss. And what happens is, probably in 40% of cases, the judge will make a direction. We have loads of administrative hearings which are completely not a waste of time. And what happens is the prosecution don't comply with the directions given. And we get to the day of the trial, and they then have to make an application. They don't do it, the case is thrown out. So, one loophole closes and another opens.
Okay, we've got time for one last question. From here.
Avril Scally, Dublin. Just two short questions, and hopefully you can answer them quickly enough. The first one is, how do you deal with a difficult client? How do you manage that? And secondly, what is your most enjoyable part of your job?
Okay. So difficult clients, we have them. I have one client, a lady who's charged with drink driving, who said she wouldn't go to a break until I struck off. It's true. I wouldn't see it without having two other people there recording. So you have to first of all work out who are the difficult clients. I've only ever sacked two clients in my life, and she was one of them. And another one who wanted me to mess around with what they said we had consumed medically. We have to manage them. And ultimately they follow our guidance. And I suppose they just have to be aware of what we're doing, why we're doing it. Talking about difficult times, I'll just tell you one story very quickly. I defended one guy, I defended several, but this particular person, I defended for drink driving and got costs, he got his money back. Defended him again for drink driving, got his money back. And he phoned me up, obviously we sent him money comes to us. I said, how do I know you paid all the money? So what are you suggesting? I said, well, phone the court and ask them. So we did. He had all his money. In any case, I'm not sure whether this would come in the category of difficult, but basically he was accusing me of being a thief. So about 3 years later, he phoned me up, hi Nick, how are you? What do you want? He said, guess what? Yes. He said, I've got another one. I said, jolly good. And we won it and you paid for it. So you have to manage your clients. The second question
Sloan, it's been an absolute honour to have you here on stage. Thank you for being
Thank you.
candid, honest, open, and thank you for the stories. There are so many more that we talked about. I'm sure you'll like to join me in thanking you for this time. Nick Freeman.